Salute you all. Thank you for listening and thanks for watching. Basically, today we are under still landlord 2 and we are in the topic of mortgages. Basically, today we are going to look at the rights, duties of a mortgager and a mortgagee. You get rights, duties of a mortgager and a mortgagee. Basically, a mortgager is a person who takes his property as security, that is land, that is a mortgager. And the mortgagee is a person who accepts the property. In this essence, let me give an example. If I have my land and I want maybe a loan from Stanbic Bank, I get my property, I become the mortgager. Stanbic Bank becomes the mortgagee. Again, let's note that. So we are going to look at the rights, duties of a mortgager and a mortgagee. We start with the rights of a mortgager. We have it is called equity of redemption. Basically, equity of redemption. Equity of redemption, when you read section 13, section 14 of the Mortgage Act, basically gives that element. Thereby, the court will compel the mortgagee to convey to the mortgager once the latter was paid the debt or discharge the obligation under the mortgage. Here, the equity of redemption works like this: that if I'm a person who got loan and took my land as security from Stanbic Bank, once I clear my loan, the bank must return my property. That's the equity of redemption, the one that I'm talking about. You get? Once I clear, I've cleared it, basically. So note that in mind. And in this essence, we look at this equity of redemption. It must not be violated by the mortgagee. You have the case of Wamala versus Musoke. Wamala versus Musoke. It was held that if a borrower wishes to retain the land within a reasonable time, he will always be allowed to do so, even if the due date is past. You get? Under that case, then when you relate it to Commercial Microfinance Limited versus Davis Edgar Kayondo, that case stated that a mortgager cannot be prevented from eventually redeeming his property on repayment of the sum advanced together with interest due and the mortgager's property costs. And secondly, after the redemption is free from all the conditions of the mortgage. So it gives an element that after the redemption, the mortgager is free from the conditions of the mortgage. Unexpressed redemption is free from all the conditions, and unexpressed stipulation, which is inconsistent with the right of redemption, will be ineffective, and a mortgager may still redeem if he had cleared. What I'm trying to drive from is that even though you sign an agreement that is inconsistent with the equity of redemption, that agreement or that provision is ineffective. You get? Is ineffective. They will just waive it away. You get? So it is ineffective. Note that in mind. The case of Stanley versus Wild ending with E, it said that ACLONG, or the equity of redemption, is void. Actually, ACLONG on the equity of redemption is void. That's the general rule. ACLONG is like something that is halting or something that is preventing the equity of redemption is void. It follows that once a mortgagee, always a mortgage. Once a mortgage, always a mortgage. Right to redeem is not merely a personal right, but an interest in the property mortgaged. This gives that the equity of redemption is not just merely a personal right, but an interest in the property mortgaged. So note that in mind in this essence. You get? So another thing what you have to bear in mind is that the right to redemption must not be excluded. And we have the case of Samuel versus Jerry and Timber and Wood. Ger is G-E-R-R. It must not be excluded. Any provision that excludes it is void. You get that gives that element. Even the right to redemption or to redeem, it can be postponed once someone has a valid what reason. You get, or it can be postponed on an agreed date, and such postponement can be declared void and voter on the equity of what of redemption. Once it is against, it can be declared what? It can be declared void in that essence. So note that in mind. And basically that is the key right of a mortgager, basically, of a mortgager. And when you look at the duties of a mortgager, the duty to repay the loan, observe covenants in the mortgage agreement, reserve a mortgage property in a tentative condition, and ensure, what do I mean a tentative condition? In a condition whereby how we found that mortgage property. Yeah, that is the tentative condition that I'm talking about, basically. Condition that is free from anything. If tentative condition basically deals in whereby realize that some essence, some areas, realize that at times realize that at times realize that a mortgage, if you have mortgaged your piece of land, and this land maybe it is flat, there's no need of you seeing that your mortgage, you start mining, removing land for brick making. Now you are making it unvaluable. You get? So read section 100, section 101. Yeah, 101. So it is on leases, but it has that element. Section 101 of the RTA. You get? Though it is on leases. You get? So those are some of the duties of a mortgagor. Then when you follow, you go to the rights of a mortgagee. Rights of a mortgagee. One of the rights of a mortgagee, a right to sue for the payment or for the price. Right to sue for the payment provided under section, when you read section 20 subsection 1 and the following, the Mortgage Act. The mortgagee can sue the mortgagor once the mortgagor fails to clear the debt. Basically, we have the case of Gordon Granton Company versus Bros. Gordon Granton Company versus Bros. Under this case, it was observed that if a mortgagee exercises his power of sale and the purchase price is less than a mortgage debt, he may sue the mortgagor for the balance or breach. Here deals in what was portrayed in this case is that, the mortgagees have power to sell the property in the case of failure of the mortgagor to pay the debt. But you realize that sometimes the land has lost value. And when he sells that land, doesn't suit, doesn't suit to the, doesn't pay his full loan. So he can sell, get that money, and also sue for the balance. You sue for the balance that I've sold land, I borrowed you 10 billion, I've sold your land, it is worth a 7. Then I can sue you for the 3 billion. So that is one of the rights of the mortgagee. The second right, appointment of a receiver, provided under section 21 of the Mortgage Act, provides that where the mortgage property is capable of generating income, a receivership is convenient mode of receiving, realizing the security. A receiver has powers to enter into possession of the mortgaged land. We have seen that many people build tenants, apartments, rentals, but they put them in the mortgage. So the mortgagee can put a receiver, and that receiver is the one to collect that money. That income from that mortgage. And that money, some of you ask that money is normally, they must also give updates to the mortgagor. You get? Because that money, it may be what can clear off a mortgage. You get? Because you see that once the receiver obtains money that clears the mortgage, then he gives back the instruments to the owner of the property. The mortgage, the equity of redemption is exercised. You get? So that is appointment of a receiver by a mortgagee. We have the case of Grindlays Bank Uganda versus Edward Boaz. Grindlays Bank Uganda versus Edward Boaz, where the Supreme Court held that the purported sale by such a receiver was declared legal and set aside. It was declared void, whereby a verbal appointment of receiver by a mortgagee's lawyer, since it contravened the equivalence of a written appointment described under the mortgage decree, whereby for you to appoint a receiver, it must be in a written document, basically. In this case, the appointment of the receiver was declared legal. Reason being, it was a verbal appointment, basically. So when you go forth, we have mortgagee's power of leasing. Basically, the mortgagee has power to lease that property, provided under Section 22 of the Mortgage Act. Basically, that is the right. Then we have also another right of a mortgagee, taking possession of the mortgaged property. Taking possession, you take custody. You are the one now, the owner, basically. When we read Section 23 and Section 24 of the Mortgage Act, basically provides that someone takes control, custody of the what? Of the mortgage property. You have the case of Barclays Bank versus Bad, Echinyoni, Bad. For the purposes of possession, an equitable mortgage was in the same possession as a legal mortgage. For the purposes of possession under this remedy. Okay. Then another right of a mortgage, foreclosure and subsequent sale or constant sale. Constant sale is provided under Section 25 of the Mortgage Act, Section 25. Then foreclosure also still, when you read Section 25 to Section 31, it has that element. Section 25 and Section maybe 31. It has that element basically. In this essence, subsequent sale, they sell in case the other party breaches. So they have to sell the what? The property. This essence, the question that says that, take for instance, we saw there under one that if the mortgagee sells property and is not worth the money, so he has to sue for the price, basically. And you note that a person can mortgage the same property in more than one bank. In more than one bank. You can have your piece of land, you mortgage it in Stanbic, you mortgage it in Central Bank, Centenary, you mortgage it in Post Bank, like in more than one. You get. But if you mortgage it to Stanbic Bank, if you are going to Centenary, you must notify Stanbic Bank, must be aware. You get. And if this person, because it is the first mortgagee who is having the title, the rest they are having agreements. You get that they are also mortgagee. So under sale, where there is subsequent sale, the first mortgagee first pays his payment, then also the second also pays, even the third, like that. If the third one doesn't get, he has to sue for the what? For the price. So refer to Section 25 to Section 31. We have the case of William versus Morgan. The case of William versus Morgan, it held that the court order is mandatory for foreclosure, and in foreclosure, it is to vest the mortgager's estate in a mortgage's full settlement of the debt. You get. So basically, note that in what? In mind. Basically, note that where the sale is not available, they must give notice to they must give, where they are going to carry out sale, they must give a notice to the mortgagor. You get. And This notice must be given when you read to section of the case of Warning versus London Manchester Association Company Limited. The mortgagee's exercise of his power to sell the mortgage property by public auction or private contract is binding on the mortgagor before completion, before it is, unless it is proved that it exercised it in a bad faith. The fact is that the contract of sale was entered in under value, and it by necessity not to prove bad faith. This essence for you, when a mortgagee is to sell the property, he must sell a notice. He must notify the mortgagor, and he must sell. The sale must be carried out after 30 days from the date of what? Notice. You get? After 30 days. That is the ultimatum. Where the sale is done before the expire of that time, the sale is done in bad faith, basically. So note that in what? In mind, basically. Basically, those are some of the rights, duties, duties of a mortgagee and a mortgagee. But other than that, thank you for listening and thank you for watching. Stay blessed.